The Supreme Court of Canada has announced that it will hear arguments in the appeal of Quebec's secularism law, known as Bill 21. The law prevents some civil servants, including judges, police officers, and teachers, from wearing religious symbols while they're at work. Teachers' unions, religious groups, and civil liberties groups have argued that the law is discriminatory. They're thrilled that it will now be before the country's highest court.
I think it's a really good decision. It only proves that debating Bill 21 is important not only to religious minorities, but the public in general.
Shelby has been allowed to continue teaching because she was already employed when the law was passed in 2019. But she says Bill 21 has hurt her career.
I cannot have a promotion as a principal, for example. If I want to move outside Montreal, I cannot really change school boards. So my freedom is really restricted.
Proponents of the law say it protects important Quebec values such as state secularism and equality between men and women. They hoped the debate would end here, but they say they're prepared to continue the fight.
The judgment from the Supreme Court of Canada will send an even stronger message to all of Canada about the validity of Bill 21.
The province, when drafting the law, preemptively invoked the constitutional notwithstanding clause to protect it from court challenges, and so far that seems to be working. Bill 21 has mostly been upheld in lower court rulings, and some other provinces have since started preemptively invoking the notwithstanding clause on other issues. But the Supreme Court is a bigger stage, and all the federal parties except the Bloc oppose Bill 21 and say Ottawa should intervene in the case.
When it's a matter of national importance and there's a national conversation about interpreting charter rights that will have an impact right around the country, we are going to be there.
The CAQ government responded with a statement saying the Quebec government will fight to the end to defend the secularism law. An intervention by the federal government in the Supreme Court would not only be a lack of respect, but could not be considered anything other than an attack on provincial autonomy. It will likely be several months before arguments are heard, and several months after that before a final decision is reached.